Hello, I'm David Gardner, and welcome to the fourth in the No5 Court of Protection podcasts. Today we'll be discussing recent capacity cases, and I'm delighted to be joined here by Avril Rushe and Laura Davidson. Avril spoke on the first of our podcasts, Laura spoke on the second, and I spoke on the third of our podcast, so you'll see we're all seasoned pros at this now. This is going to be an interesting podcast, I think, hopefully for many of you practitioners out there who are dealing with the onslaught of new cases on capacity. And so whether you're listening to this in the bath, walking your dog, in the car, I hope this is of use to you all. And certainly something a little bit different from the white noise that is the number of webinars that everybody's being invited to at the moment. In a moment, I'm going to pass over to Avril, because Avril's going to talk to us about the recent case of the London Borough of Tower Hamlets and PB, where there's some interesting discussions in relation to unwise decisions. And then after that, Laura is going to speak about a local authority and JB, which is another case adding to the multitude of cases on capacity to consent to sex. First off, we'll go to Avril then. So, Avril, London Borough of Tower Hamlets and PB. We know that Section 1(4) of the Mental Capacity Act suggests that when P has made a decision that is an unwise decision, that doesn't necessarily mean that they lack capacity to make said decision. So we've got a bit of comment on this from the court in PB. Do you want to talk us through what was decided?
Thank you, David. Yes, so just to give you a little bit of background to the case, it concerned a 52-year-old man. He had a history of long-term alcohol abuse. He had alcohol-related brain damage and also dissocial personality disorder. Most of his life was spent living in hostels or supported placements, and it would appear that each of these had actually broken down as a direct consequence of his alcohol abuse and subsequent difficult or sometimes aggressive behaviour. And the case concerned his capacity to make decisions concerning his residence and care. So obviously looking at LBX, but it also required an evaluation of whether he understood the impact that his drinking could have on his residence and care arrangements. Now, he had been in a supported living placement. He was evicted from this and spent 3 months on the streets back in February 2019. He had multiple hospital admissions. It culminated in a serious hypoxic incident. And during his hospitalisation, there was some forced sobriety. He was then put into an alcohol recovery centre. Of course, the hope was that he would abstain from alcohol use, but his hope was that he would reach a state of moderation. An application was lodged then with the court in June 2019, and that was seeking authorisation for a planned discharge to a specialist supported living placement. And the package of care he would receive there would restrict his access to alcohol. So he was not permitted to leave the unit unescorted in order to prevent him from drinking. Now, they decided to test his statement that he wanted to reach moderation. So they allowed him to have 2 hours then unescorted leave. Suffice to say, the trial was not a success. He returned far later than he should have on a number of occasions, was suspected that he had been drinking, he'd been abusive to staff members, he'd urinated and vomited on one occasion in his bed overnight, so quite dangerous to him. They went back then to being unable to leave unless he was escorted, but he was able to access alcohol somehow overnight as he was left in the unit on his own at night time. Now, the consultant psychiatrist in the case produced 3 reports. The very first report stated that PB seriously overestimates his ability to keep his alcohol dependence under control, but he does have capacity to make decisions about his residence and care. So that was on 3 grounds. First, the minimisations, the rationalisations, the justifications, despite all evidence to the contrary, are actually typical of persons with substance dependence, and it doesn't mean that they lack capacity. Secondly, the psychiatrist found that he did not exclude the possibility that he could die, and he defended his decision to continue drinking. And finally, the answers that PB gave showed a sufficient understanding and acceptance of the risks to his health were he to go back to his drinking. There were then 2 more addendum reports, and these came after the failed trial. And this is something that Mr. Justice Hayden later in the judgment points out as being significant. The consultant psychiatrist revised the information that he considered to be relevant information for PB to decide on drinking alcohol. And he stated that the relevant information was, if PB is allowed to go out unsupervised, he will drink to excess. Drinking alcohol to excess will result in him becoming aggressive, will likely result in him then losing his placement, becoming homeless. And drinking alcohol to excess will result in him developing life-threatening physical problems. It could include aspiration of his own vomit, hospitalisation, and a high possibility of dying. Now, although the consultant psychiatrist explicitly concluded that PB was able to understand and weigh this relevant information, and PB himself accepted that he had drunk to excess when unescorted, despite this, the consultant psychiatrist found that PB lacked capacity to make decisions about his residence and care, as he did not accept that recent episodes have demonstrated beyond doubt that he's unable to control his drinking, so that it is in fact certain that he will continue to drink to excess if he's not supervised. And the fact that PB did not accept this meant that he lacked capacity. The second addendum, in quite stringent terms, stated PB is unable in his decision making to use the fact that he does not have control over his drinking. Instead of that true fact of his lack of control, his thinking is informed by the belief that he will be able to contain his drinking within relatively safe limits. Mr. Justice Hayden, in his judgment, looked at the concept of unwise decisions. And he said a person is, of course, not to be treated as unable to make a decision merely because he makes an unwise decision. The law doesn't require us to behave in a manner that deserves approbation from the prudent, the wise, or the good. And he reminded us that the focus ought to be the ability to take the decision, not on the outcome of that decision. He pointed to the decision of Lord Justice Macfarlane in PC and City of York, and he said that that captured and distilled the true essence of the principle in relation to unwise decisions. Lord Justice Macfarlane stated, there is a space between an unwise decision and one which an individual does not have the mental capacity to take. And it's important to respect that space and to ensure that it is preserved, for it is within that space that an individual's autonomy operates. And this is something that Mr. Justice Hayden returned to again and again in the judgment, speaking about this space that we had to preserve for individuals. Because fundamentally, the Act emphasises the right of every individual in exercising his or her personal autonomy to make bad decisions, even extending, as Mr. Justice Hayden said, to those with potentially catastrophic consequences. Turning to the test that was imposed by the consultant psychiatrist, Mr. Justice Hayden stated that it was a very challenging test of capacity. He said it significantly eroded the space that Lord Justice Macfarlane spoke about. He said it would have the alarming effect of rendering most addicts incapacitous if they're unable to agree with the precepts of that test. And also a bit of a catch-22, because if they did agree that it was beyond doubt that they were unable to control their drinking and certain that they would drink to excess, then he said that likely a deprivation of liberty would be almost inevitable. He reminded us that the test of capacity must not be too high, and he looked at the Sheffield City Council and E case, where we looked at the capacity to marry, and he said that that should be applied across the board in all decisions in which we have to assess capacity, lest it would operate, in the words, as an unfair, unnecessary and indeed discriminatory bar against the mentally disabled. Looking at PB himself, Mr. Justice Hayden found that there's no doubt that PB seriously overestimates his ability to keep his alcohol dependence under control, but his analysis of his dependency on alcohol was in a way that was both articulate and rational. And although there was a huge gap between his aspiration to be a moderate drinker and the likely reality, that did not take away from the rational and articulate thought process that had underpinned his reasoning. And as Mr. Justice Hayden reminded us, self-evidently, not every addict who is in some degree of denial about their addiction can be regarded as incapacitous. He found that the consultant psychiatrist had changed his opinion after the failed trial, and had no doubt that what was behind this was him recoiling from PB's unwise decision, a decision that may have hastened his death. But Mr. Justice Hayden reminded us that, like anyone, of course, PB is entitled to make a bad decision if he chooses to do so. This is where we find the respect for individual autonomy. He drew a parallel with the case of PC and another versus City of York Council, where there we had obviously understandable professional concern for a vulnerable woman, which led to the construction of a too high a test motivated by a desire to protect her. He found that in this case, the consultant psychiatrist had potentially sympathy towards PB's vulnerability, and even if an entirely accurate picture of his situation, he allowed this to cast a shadow over the forensic vigour that he was required to use in his assessment. Again, he states that we're concerned with that space, giving the individual this space to make a decision, even if the outcome of it may be unwise. In conclusion, he found that that test that was set was too high, and PB did have capacity to make decisions about his care and residence. And some final observations that he made to give us some nice take-on points. So the Court of Protection is there to protect P, but it's not just physical, emotional and medical welfare, it's also to protect P's autonomy. And although we have this human instinct to protect vulnerable people from unwise decisions, we can't allow this to override their fundamental right to make their own decisions. As he stated, misguided paternalism has no place in the Court of Protection. And interestingly, he highlighted the fact that even though in cases we have factual similarities, the Court of Protection is a uniquely fact-sensitive jurisdiction, and we ought not to be drawn into comparisons, but rather look at each case on its own and the specific facts. He also cautioned against having artificial conceptual silos. So criteria by which capacity is evaluated on any issue ought to be sensitive to the particular circumstances of the case. And going back to his point that the consultant psychiatrist had possibly allowed the forensic rigour which was required of him to be lost, professionals' instinct to achieve what's in P's best interests, objectively speaking, should not influence how they formulate the criteria on which capacity is assessed. So it really was a very interesting case, worth having a read. David, how did you find it?
Yeah, I agree, Avril. It's a really very interesting case. I'm really grateful for your quite insightful analysis. I'm sure that's been really helpful to people. One of the interesting things I find in this kind of field, certainly in cases I've dealt with involving where P has alcohol dependence issues, is that it can often be said that P is unable to weigh the relevant information because they in effect give no weight to the alcohol dependence syndrome that they've been diagnosed with, or give no weight to the impact of their drinking. And in fairness, Mr. Justice Hayden does mention, doesn't he, in the judgment, and gives reference to the judgment of Mr. Justice MacDonald in King's College NHS Foundation Trust and C&V. What did you think about that element, Avril? How does that impact the weight aspect with unwise decision making?
Well, the two are intimately bound up with one another, and that did come across in the judgment. The weight one gives to one of the pieces of relevant information might be seen as objectively unwise. However, as set out in Section 3 of the Mental Capacity Act, the test for the inability to make a particular decision only requires the person to weigh the information. It's not required that they give a certain weight to any of the pieces of relevant information. The weight that is given, that is a matter for the decision maker themselves, and of course will be based on their own personal values, outlook, beliefs, and might be objectively unwise.
That's great, Avril. So thank you very much. That's a really helpful and useful insight into a very important case. We're going to move on now. Laura Davidson is going to speak to us about the case of a local authority and JB. That's a case dealing with capacity to consent to sex, or perhaps we should be discussing to engage in sex. Laura, the case of JB, well, we know that Section 27(1)(c) of the Mental Capacity Act means that if P lacks capacity to consent to sex, then the court's hands are effectively tied and it can't make decisions facilitating. But what does JB say to us in terms of the great number of cases we've had on this issue?
Yes, David. A local authority against JB is a much welcome decision from the Court of Appeal, which begins with a comprehensive review of the law on capacity to enter into a sexual relationship. And it's cut through the confusing mire of largely overdue case law to bring a degree of clarity and refinement to the requisite capacity test. P, the protected person, who in this case was JB, had Asperger's syndrome, marked difficulties in adaptive functioning and social interactions, and severe epilepsy. Although he didn't have a learning disability, he did have deficits in his global intellectual functioning. And like P in Re A, restrictions were placed on his access to social media and the internet within his supported living placement, because often he would inappropriately contact women and send them explicit sexual messages and harass them online. So due to the high risk that he would commit a sexual assault when pursuing a sexual relationship, an allegation of which had already been subject to police investigation, JB also had one-to-one supervision in the community. So Court of Protection proceedings were brought. The parties agreed that JB lacked capacity to make decisions on residence, care and contact with others, and his use of the internet and social media. An independent clinical psychologist considered him unable to understand the concept of consent in a sexual relationship. And this was due to his limited understanding of the emotional state or intentions of others. Despite repeated information provided to the contrary, he simply failed to understand that someone might either refuse consent or potentially change their mind about giving consent, and that meant that rape was a possible outcome. He was assessed by the clinical psychologist as lacking capacity, but since previous case law hadn't identified the consent of a potential partner as relevant information under Section 3.1 of the Mental Capacity Act, relevant in relation to decisions about participating in sexual relations, the expert was instructed by the official solicitor to reconsider that assessment. Applying the legal test as instructed, the independent clinical psychologist then found that JB did have the requisite capacity since he understood the mechanics of the sexual act and the risks of pregnancy and of sexually transmitted diseases. At first instance, Mrs. Justice Roberts held that sexual intercourse was a primal expression of our existence as sexual beings, involving conceptual issues difficult for the capacitous to grasp. And she insisted, in accordance with past case law, that the test should be as simple as possible, which is absolutely correct. It should be, so as not to make the bar too high and be discriminatory against people with learning disabilities. The judge held in the court at first instance that, in her judgment, knowledge of the other party's consent to the proposed sexual activity went to whether or not P chose to exercise his capacity to engage in that activity. The local authority appealed against the decision that JB had capacity to consent to sexual relations. A unanimous judgment in the Court of Appeal was given by Lord Justice Baker, who listeners will be aware is a highly experienced Court of Protection judge. And actually, if truth be told, he was my favourite High Court judge before his elevation to the Appellate Court. He overturned Mrs. Justice Roberts' decision and remitted the matter back to the First Instance Court, holding that previous case law had asked the wrong question. The unhelpful tendency had been to frame the decision-making in terms of capacity to consent to sexual relations, whereas giving consent to sexual relations is only part of the decision-making process. So in paragraph 93 of the judgment, he held that the fundamental decision, which should normally be assessed in most cases, was whether to engage in sexual relations. Even though there was an instinctual emotional component of sexual desire, it was not to the exclusion of a cerebral element. The court therefore held that amongst the matters which every person engaging in sexual relations must think about is whether the other person is consenting, and I think nobody would disagree with that. The judge at first instance had considered that the exercise of capacity which resulted in a criminal act ought to be policed by the criminal law rather than the Court of Protection. But apart from the fact that prosecution would be, of course, subject to discretion to prosecute, the Court of Protection had a core duty to protect P from harm. The Appellate Court pointed out in paragraph 94 of the judgment that a fundamental part of the information relevant to the decision was the ability to understand that sexual relations must only take place if their partner consents, and only for as long as that consent lasts. A broad understanding was all that was needed. Now, I suspect that Mrs. Justice Roberts believes she really had got to the nub of the issue in holding that knowledge of the other party's consent to the proposed sexual activity went to whether or not P chose to exercise his capacity to engage in it. However, Lord Justice Baker expressly disapproved that finding and held in the judgment that if the consensuality of sexual relations is part of the relevant information, it plainly relates to capacity itself, rather than the exercise of capacity. Perhaps unsurprisingly, the court re-emphasised that previous guidance had been just that, guidance. Relevant information must be, and I quote, firmly anchored to the decision in question. No doubt listeners who practice in this area of the law will recollect the lengthy and rather worryingly complex list of relevant information specified by Mr. Justice Cobb last year on capacity to use social media and the internet in Re A and Adult, and then subsequently in Re B. The Court of Appeal, however, identified only 5 matters, helpfully in paragraph 100, so you can quickly and easily go to it in the judgment, as information relevant to the decision on whether or not to engage in sexual relations that P must understand. So I'll just summarise them here. The first is the sexual nature and character, including the mechanics of the act of sexual intercourse. The second, that the other person must have capacity to consent to sexual activity and must in fact consent prior to and throughout. The third, that P can consent to or refuse sexual relations. Fourthly, that a reasonably foreseeable consequence of heterosexual intercourse is pregnancy, which of course we've heard before in numerous cases. And fifthly, that health risks, particularly the acquisition of sexually transmitted and transmissible infections, may result, which precautions like condom use can reduce. The Court of Appeal further diverged from Mrs. Justice Roberts' view that an understanding of consent would demand a refined or nuanced analysis that those with full capacity would not need to undertake, i.e. be discriminatory. Rather, Lord Justice Baker, rightly in my view, held that it is something which any person engaging in sexual relations has to consider at all times, albeit that certain individuals might choose to ignore consent and commit sexual assault or rape. The court also disagreed with the finding at first instance that since all humans make mistakes, it was excessive to require P to understand that consent from a partner was a prerequisite. Of course, Section 1.4 of the Mental Capacity Act, as we've heard about in PB, which Avril has just discussed, states that a person is not to be treated as unable to make a decision merely because he makes an unwise decision. However, JB's inability to understand relevant information was a different matter altogether, because he was described by the clinical psychologist as visibly shaken at the idea that a partner would be able to withdraw consent. He had such a fixed view over several assessments that if a person gives consent, then she's already given consent and you have to go through with it to the end. I'm quoting, "She can't change her mind if you are already doing it, because it's her fault in the first place for saying yes, already said yes, and you've got your chance." So, accordingly, the appeal was allowed and the decision was set aside and the decision was remitted for reconsideration.
Thanks, Laura. That's a really helpful summary of the JB appeal. And as you observed, there's quite a lot of case law on this area already. So what do you think? Is this the end of the matter on the capacity test concerning consent to sexual relations?
That's a good question, David. In my view, the decision to overturn the judgment at first instance was the right one, but I'm sure there'll be further litigation arising from it at some stage. There are a few things that could be challenged potentially. One dichotomy arising from the judgment is this. So a person may be found to lack capacity to engage in sexual relations because they fail to understand either that someone else, 1, might not consent, or 2, might withdraw consent. This information must be understood, even if a specific partner is known to be equally eager for a union with P. So the only way around this barrier to a sexual relationship between the two would be for the local authority and any carers and supporters to continue to provide the relevant information in an attempt to educate and support the person and to evince the requisite understanding, which of course so far has proved impossible in JB's case. Another dichotomy could be this. So the appellate court reiterated what has been said time and time again in Court of Protection cases, that the test for capacity must be simple, not least to avoid discrimination against those with learning disabilities. And of course the court was insistent about that in PB, as we've heard. A similar concern troubled Mrs. Justice Roberts, but in paragraph 94 of the Court of Appeal judgment, the court held that the relevant information JB needed to understand, use and weigh inevitably includes the fact that any person with whom P engages in sexual activity must be able to consent to such activity and does in fact consent to it. Now, when you break that down, it's actually rather complex. The average lay person would struggle to define and or understand what is meant by an ability to consent. I suspect that the framing was just a clumsy way of reiterating what was said in the next sentence, which was, a person who does not understand that sexual relations must only take place when and only for as long as the other person is consenting is unable to understand the fundamental part of the information relevant to the decision whether or not to engage in such relations. That description is a somewhat easier test, I think. Essentially, do both partners consent rather than do both have the capacity to consent. Then the door has also been left open for an appeal on the fact that the Court of Appeal declined to answer the question whether the information relevant to the decision whether to engage in sexual relations must always include all of the matters identified in paragraph 100, because that was irrelevant to the appeal under consideration. The reason for this is clearly due to Lord Justice Baker's frustration at the plentiful obiter dicta in previous case law, which tended to be overturned when the issue came up in a specific case. In my view, it's abundantly clear that information relevant to the decision must relate to the specific factual context, given that if it's not relevant information, why must P understand it at all? And this view is expressed in numerous cases, including in PC and NC against the City of York Council, the 2013 case. And then finally, the biggest lacuna, I think, arises from the clarification in paragraph 93 of the judgment that expressing capacity in terms of engagement in sexual relations rather than consent to it is how such capacity questions should normally be assessed in most cases. Clearly that begs the question, well, when might it not? I'm sure there'll be various future cases claiming to be an exception.
Thanks, Laura. That was really, really useful and very, very interesting. It remains for me just now to say thank you to both Avril and Laura for their excellent and authoritative insights into two very interesting cases. I hope that they've been useful to you as well in taking forward your practice. I certainly feel I've learnt a lot. I mean, certainly we've learnt to respect the space between an unwise decision and a lack of capacity. We've learnt the relevant information on capacity to engage in sex, although, as Laura says, watch this space. Perhaps most importantly of all, though, we've learnt Laura's favourite High Court judge. Thank you very much to you all for listening, and hopefully the space in between you listening to this podcast and instructing a member of our Court of Protection group won't be too long. Thanks very much.